the missing person, and really the heart of this panel, is Bennett Capers from Fordham University. We are all just contributing editors, or rather writers, to a chapter, each of us, in a really incredible book project that Bennett Capers and others have spearheaded. So I'll provide some orienting remarks as if I was Professor Capers. These are big shoes to fill. And then we'll get into all the separate presentations. And then personally, I just want to express gratitude to everyone from the Critical Race Studies program. This has been such a phenomenal gathering, such a well-run conference. I was fortunate enough as a student to work with Professor Derek Bell. I was his teaching assistant in constitutional law. So this was the only way I knew how to think about the law. And it feels very much like a homecoming to be here in this space with everyone. So thank you. Let's see. There we go. We'll start out by discussing the book project, which we all have contributing. We're contributing authors and chapters in it. And we will start with Montre Kerdine, who's going to talk about race is evidence, evidence is race. We'll move on to Daniel Harawa, who will be talking about Pena Rodriguez versus Colorado, jury secrecy, and the performance of racial justice. I'll then present on presumed credible police officer testimony. We'll have Ngozi Okedebe, who's going to talk about democratic evidence. And then Anna Roberts will be talking about teaching impeachment. And we'll have time for Q&A at the end. As each person starts their chapter, just sort of introduce the institution that you're from. So this all came out of a book project. I mentioned Bennett Capers is one of the contributing editors, who's at Fordham, Jasmine Harris, who's at Penn, and then Julia Simon-Kerr at University of Connecticut. These are all scholars, not primarily in evidence, other areas they do write in, but they're part of this sort of nascent movement of bringing a critical race lens, a critical legal studies lens to the law of evidence. It's been one of the topics I think that hasn't been looked at with a critical lens relative to maybe other areas of the law. And I've listed some of the other contributing authors that aren't physically here with us today. I am thrilled about this book. I know all of us do teach evidence at our respective institutions, evidence seminars, and this is exactly the kind of anchoring scholarship that I think we've all been hoping for. Some of us have pieced it together, through law review articles. Jasmine Gonzalez-Rose, she's one of the contributing authors, has that incredible article, I want to say it's 2017, from the Minnesota Law Review on applying a critical race lens to evidence. And critical evidence is really something that builds on the tradition of critical legal theories, critical race theory. It recognizes that evidence law is fundamentally about power. It's setting boundaries for whose voices will be heard, which witnesses get to testify, who is deemed an expert, what privileges exist, and then of course what types of knowledge will be accepted and are cognizable in court that a fact finder can then rely on, that the judge can then rely on when making findings of law. It also exposes the way that systems of privilege, certain insiders, those that already have power, reify that power, and then it simultaneously silences and also discredits marginalized groups, marginalized voices. We see that in people with prior criminal convictions who are deemed not to be credible. They have less trustworthiness, a diminished character for trustworthiness because they have a criminal conviction. We know that has a disproportionate impact on marginalized groups, black people, brown people. And it's very much the work of Anna Roberts to lift that up. We also, through applying a critical lens to evidence law, it shows that logic, knowledge, determinations of truth, they don't exist in a vacuum. They're very part of sort of the social context, cultural context, and cultural norms, and so we're bringing that awareness to the law of evidence. Let's see, and then again, this is related to the social context in which evidence questions are asked and answered, informs where we start and where logic takes us. And then lastly, critical evidence rejects this idea that the rules of evidence are neutral, that they're the same from one context to the next, and non-partisan. And so some of what applying a critical lens can do is that it considers how it is that this Anglo-American legal proceedings tradition impacts evidence law today. It questions the common law foundations. Those of us that teach evidence, you're often starting with the fact, well, you may find this concept problematic, but it's got these common law origins, so we're just going to go with it and accept it. And then areas in which it can be really generative to think about and question the common law foundations of some of these evidentiary norms are in impeaching with prior convictions. And what sort of privileges are recognized. Many of the privileges do correspond with people that have privilege. People who have access to doctors and lawyers, people who have access to the ability to be married, and there's a marital privilege. So it starts to question some of those norms. Race can be evidence, but we often don't talk about it. Montre's work is critical here, as is Bennett Capers. And it's often something that, it's the first thing a fact finder notices. It's the first thing that a judge notices. But the rules of evidence often don't account for that. Critical evidence also questions some of these universalities that we accept, these inferences that we're supposed to accept within the context of, say, hearsay. So adoptive admission. Through somebody's, question can be posed to someone and their silence given certain conditions, we can infer that, this person now adopts the statement that I just made. And so we start to question some of that when we apply a critical lens. And then evidence of flight as being relevant to show guilt. We know there are many reasons that someone can flee from law enforcement that aren't necessarily connected to guilt. And so some of what critical evidence can do, it very much informs the way all of us teach. I'm hopeful that it's stimulating some of my student learning. I find that when I present to them a critical approach to some of these concepts, that it starts to make more sense to them when they realize, like, this isn't an inference I have to accept. There's another way of thinking about this. It enables expansive knowledge production. It unlocks all of these different areas, really fertile areas of scholarship. And then it can inspire rule change. And I think that's one of the most exciting things about questioning some of these long-standing traditions is that there are ways of changing the federal rules of evidence, of the rules in states. There's actually been pretty dramatic changes to evidence in the 90s in terms of sort of prior bad acts as they related to sexual assault cases, people that were complainants in sexual assault, sexual molestation cases. So there was this long-standing tradition of prohibition against propensity evidence, and that was essentially put aside, at least with the federal rules of evidence, for a certain set of cases. And so there are ways to change the rules of evidence, and Anna Roberts is leading some of that effort with Rule 609. It can also spur jury instructions. We may have views about how effective jury instructions are, but in New York State, for instance, it's now required upon request and when it's relevant in a case to give instructions about the fallibility of cross-racial witness identification. And that came out of a case from the New York Court of Appeals. That's our high court in 2017. And then something that I write about and I'll present about is this idea that it expands whose voices we consider as experts. And that's been really effective and powerful, in particular within the criminal context for marginalized groups. And hopefully, with this new landscape of scholarship, it'll start to impact and alter the way that trial judges are starting to exercise their discretion, particularly as it comes to relevance. And then, of course, when you have 403 objections, weighing that probative value against prejudice and other issues on the other side of the scale. So with that, I want to get to our first presenter, who is Montre.
Thank you very much. Thank you for being here. I want to thank Anna for all of her hard work in bringing us together in multiple panels over the years, and just all of her excellent work that she's done in this area. So I'll tell you a little bit about my work. I started working on race and evidence when I first started teaching, not long after I taught my first evidence class. I remember I was at Washington and Lee That was my first law school. I'm currently at the University of Alabama School of Law, and have been there for the past 18 years. But at my first law school at Washington and Lee, I taught evidence, and I remember maybe sitting in a classroom like this, maybe a little bit bigger, and it was a majority white class. And there were maybe 3 or 4 black students, and I think that was maybe the extent of the diversity in the classroom. But I remember teaching Rule 609. And Rule 609 is the rule, you know, those of you who are familiar with evidence, or even if you're not, if you've watched, law TV shows or movies, you may have seen Rule 609 in action. But it's the rule that allows for what we call the impeachment of a witness on the basis of their criminal record. And Anna's done a lot of work in that area, and she'll talk more about it. But the way it often works is that someone will get on the stand, and it could be a criminal defendant, and they will have been, on direct, will have answered questions by the lawyer who called them, and then on cross-examination, you see this more dramatically in the movies and on TV shows. They will be asked if they're the same, Jane Doe who was arrested and convicted of some felony. All right, it's an instant reduction, diminishment of that person's credibility, and intended to be so. And I remember teaching this rule and the mechanics of Rule 609 at Washington and Lee. And there was a black woman sitting close to the front. I can almost see it right now. She's extremely frustrated. And she finally spoke, and she talked about the unfairness of this rule as it relates to people of color, and also the unfairness, Ngozi will talk about democratic rulemaking, but the unfairness of the rulemaking process that's not inclusive, that doesn't take into account historical discrimination of people of color, and that will produce a rule like this. And I just remember her frustration so clearly. And so I started working on an article about Rule 609. My first article was about foreign judgment recognition, something very different from the work I ended up doing for most of my career up to now. But at the time, when I worked on my first article on 609, and I dealt with the racial implications of Rule 609, at the time there wasn't much out there on race and evidence. The assumption was just that the evidence rules are neutral. So fast forward a little bit, I'm at the University of Alabama, and I'm going up for tenure. And the chair of my tenure committee, as I recall, or a member of my tenure committee, who wrote an evaluation. I had outside reviews, but he wrote an evaluation of my Rule 609 and race article, who had coincidentally also been a part of the advisory committee in Alabama for Rule 609. But I think they had already decided I'm going to get tenure, so we'll write a nice evaluation, but we're going to stick it to her a little bit. She talks too much about race when she's talking about Rule 609. Now, mind you, the same person who probably shouldn't have been doing the evaluation, because he was on the rules committee that adopted Alabama's version of Rule 609, and he talks about it. I mean, he freely admits his bias, but he says she talks too much about race. She should stick to talking about Rule 609. To me, they weren't. You can't separate them, right? So one of the points I made in that article is that race is evidence. What I did in the article, at the time, I think, was to try to meticulously go through and prove the racial history of Rule 609 and the racial implications of it. I had a lot of data, I had a lot of research. It was a long article, could have been a book. In fact, I wish I had made it a book, but it's early in my career. And so in a way, this chapter is it's a response to myself, a critique of myself back in 2009, and also a response to the guy who said she writes too much about race, she should stick to talking about 609. Because in this article, I'm challenging myself, and I think all of us, to move beyond trying to prove so much that the rules are racist. Mm-hmm. Okay, so what I'll do is I'll read an excerpt from the piece, and bear with me for a second, because I have it on my iPhone. As is the American legal system, the development of American evidentiary law is deeply flawed, from foundational level to the present. Consider the fact that huge swaths of the American population, whose lives were regulated and impacted by courtroom decisions, were completely shut out of the court and trial process. What would the evidentiary regime look like if it had been created and developed in an equitable society? What if there had been no competency rules excluding people of color from testifying against white people? What if people of color and women had been equally free as white men to become lawyers and judges at the founding and prior to the founding of our nation? What crucial jurisprudential developments have we missed because of racism and racial exclusion? What progress and innovation in our legal system, including our rules of evidence, simply never occurred because of sexism and the intersection of racism and sexism? How has the growth of evidence law been stunted and warped because so many in our society did not have a representative seat at the table? These are questions we don't spend enough time pondering, but we need to sit with them for a while. So often we expend our energy, and that's what I did back in 2009. So often we expend our energy researching and documenting affirmative evidence of discrimination when we fail to acknowledge and give due attention to the glaring omissions in our judicial system that are a direct result of racism and white male dominance. We must think systemically about the ways in which racism and white male privilege shaped our entire system, affirmatively and by omission and exclusion, including our evidentiary framework. It's simply not enough to look at individual rules and apply racial critique to them. To be clear, we need to do that work, and I value all of our work in that area. We need to do that, but it's just a starting place. And if we stop there or operate as though we are required to demonstrate or affirmatively prove the racial bias in each rule, we fall into the trap of always carrying the burden of proving racism, which is exhausting, I know I'm tired, unfair, and often inefficient. Indeed, this heavy burden that our legal system and larger society often places on people of color is a cruel silencing tactic. What I have found is that those who choose to deny what is so obviously a part of our history and what still haunts us today, for those people, no amount of evidence that you ever show them is going to be enough. And given this history of racial exclusion, why should we have to affirmatively prove that racism is embedded in our American legal system? When has our justice system ever affirmatively proven its fairness to people of color? Okay, I'll stop there, but my point that I'm making is that so often we get stumped in our scholarship because we're trying to do what I did back in 2009, which is meticulously prove it, when we should rely on an evidentiary principle called a presumption, okay? Alexis is going to talk about presumptions with police expertise, and she does beautiful work in that area. The presumption that they get of credibility. Why is it that we're presuming the fairness of the system? Make the system. This is, and I understand that practitioners are out there and they have evidentiary burdens that they need to carry. I get that, and they have to make arguments. But I think also what our role is to, as scholars, is at least in part to imagine what it should be like. What if it were the case that the system is presumed what it really is, which is racist? It is. How could it not be? Okay, so if we start from that presumption, we free ourselves, and we open up, a means of expression. A lot of us have been silenced by people in the academy, especially, who tell us we have to prove it. We have to, the Supreme Court is doing the same. We have to prove it. They give this high burden. So what I'm doing in this chapter is freeing myself and saying, look, the system should be presumed what it is. It can rebut it, because that's how presumptions work, it's rebuttable. But let's move beyond forcing ourselves to always do that hard work which exhausts us, burns us out, and silences us. So the other part of my paper is to really think about how race, and to articulate this, how evidence rather can be used as a way to think about race. So we talk about what we're doing, what we've been doing up to now, what I've been doing up to now, is using race as a critique of the evidence rules. But what I do, and part of my title is flipping the script, is to think about how evidence can help us understand race better. So that's one of the things I'm doing with the presumptions, right? The presumption of racism. The other thing I think about when I think about presumptions, I talk about this in the paper, I think about the ways we're already doing that in critical race scholarship, in the critical space generally. I think about, some of you may have read these 2 volumes, the work Presumed Incompetent. Think about that, presumed incompetent. That's powerful language. I teach from chapters from that book. And for those of you who aren't familiar, Presumed Incompetent is a collection of essays from women of color, mostly women of color, talking about the experiences of women in color in the academy across disciplines. Okay, and I teach that. But think about that language, presumed incompetent. Within presumed incompetent, these women, these people of color are giving their testimony. Think about the power of testimony, and I talk about testimony and the history of testimony in the piece. Again, using evidence to theorize about race, and that goes with the tradition of critical race theory. In fact, I was inspired, and I'll stop here, I was inspired very early on to write about race as evidence because of the work of people like Cheryl Harris with whiteness as property. And then my own mentor, Dorothy Brown, who's done her, the amazing work, the whiteness of wealth, but also, thinking about race as a tax. So following in that tradition, what we do with evidence up to now, what we've done is largely use race to talk about evidence, but let's use evidence to talk about race as well. So I'll stop there. Thank you very much.
Okay, next we have Daniel.
Hi, good afternoon. I am thrilled to be here and really honored to be a part of this celebration and conversation. So my article is about Peña-Rodriguez, jury secrecy, and how we perform, or how courts perform, the idea of racial justice. And I came at this topic honestly. So after law school, I was an appellate public defender, and I always found it weird that I would get these transcripts and I had to figure out what went wrong in my client's trial. And part of that was figuring out, well, how did the story land with the jury? How should it have landed with the jury if no errors were made? But you never actually hear from the jury, right? So I'm doing this reconstructing of trial and what would have mattered, but we never hear from the decision makers in the case. And that always just fascinated me, that I was trying to do something, engage in this exercise, without really knowing how the evidence landed in a particular case for the people who sat in judgment. And then after I left PDS, I went to the NAACP Legal Defense Fund, where a lot of my work focused on juror bias, jury diversity. And I remember going down to Louisiana and talking to 2 older black men who had been on non-unanimous juries. And they cried. And they said, you have no idea what it was like to be in that jury room and to know that your voice won't matter. The way people talked to us, the way they treated us, they wouldn't have a lunch with us. And it was moving to see these 2 60-something-year-old men sit in tears and talk about their experiences on a jury. And so that just made me wonder, are juries good for black people? We have no idea what happens in a jury room. We have no idea what jurors think about, what they say. And as I would start to have this question reverberate in my mind, Peña-Rodriguez versus Colorado came out in 2017. And for those who don't know, that case is about a juror who was an ex-law enforcement officer who espoused all kinds of anti-Mexican bias, including statements saying that he believed that Mexican men had a bravado that caused them to think they could do whatever they want with women. He said that he didn't believe Mr. Pena Rodriguez's alibi witness because he was an illegal, even though he was a documented resident, and even though one's immigration status has nothing to do with their credibility. And just statement after statement after statement evincing this kind of clear anti-Hispanic bias. And in that case, the issue was whether, so there's this general rule, Rule 608 in the Federal Rules of Evidence, that says you can't really inquire into what happens in the jury room. Jury deliberations are secret by design. We call the jury a black box for a reason. And the reason is supposed to be that it allows for kind of free-flowing discussions. The fact that we don't know what happens in the jury room is supposed to work in our benefit, we're told, because people feel free to speak their mind. They feel free to kind of speak without worrying about their words coming back to haunt them. They may kind of weigh the evidence in a case that may be politically unpopular. They may nullify if they think nullification is warranted. And so this idea, it's hammered into evidence law that this secrecy is good for us, right? The secrecy is valuable. The secrecy serves a purpose. And then in Pena Rodriguez, we had to ask, or the court had to ask the question, well, should the secrecy stand even in the face of clear racism? And in that case, the court said, no, there needs to be a racial bias exception to what's called the no impeachment rule, to jury secrecy. And on its face, that seems like a very positive decision for those who care about racial equity in any kind of way, right? The court said, even though this rule is centuries old, even though we borrowed it from England, that we need this racial bias exception, and that we're going to apply it here such that a court can hear evidence of what happened in Mr. Pena Rodriguez's jury, and a court can consider that when deciding whether or not Mr. Pena Rodriguez deserves a new trial before a fair tribunal. But then if you look a little bit deeper at the standard the court set, it really causes you to wonder what exactly the court was trying to do there. So to activate this racial bias exception, there needs to be two things. One, the racial bias must be quote unquote overt. And two, you have to show that the racial bias significantly motivated the juror's vote to convict. And that got me thinking, well, why would racial bias need to be overt to trigger this exception, right? We know racial bias is expressed in all kinds of ways, both overt, covert. We know there's implicit biases, so why must it be the case that we only care about overt racial bias affecting our trials? If racial bias is bad, if racial bias has no role, according to the Supreme Court, in the administration of quote-unquote justice, then why would we only focus on overt racial bias? And then I thought, well, and why do we need to show that the bias significantly motivated one's vote, right? First of all, we don't know how bias affects our thought processes, just as a general matter. We all have biases. They impact what we do, what we say, all the time in imperceptible ways. So imagine you're in a room with 11 other people and somebody feels comfortable enough to express overt racial bias. At that point, you would think, well, who knows how that bias is influencing their decision making? But we know they have it. And so why wouldn't we just presume that that bias influenced them in some kind of way, especially if they feel comfortable enough to speak it in front of strangers? But the court said, no, you need to make that showing of proof. And so in an article I wrote a few years ago, I just started to ask, well, are defendants able to kind of meet this standard? And the answer is no. In the past almost 10 years that Pena Rodriguez has been on the books, only 2 criminal defendants have been able to successfully raise a juror bias claim. Courts have rejected juror bias claims, even though there has been evidence that a juror called a fellow juror an N-word lover because she expressed sympathy for the black defendant. A court has found the standard wasn't met when a juror said that the defendant must be guilty of murder because he's from El Salvador, and Salvadorans are more likely to murder people. And there's just example after example of what I would consider to be shocking instances of bias influencing the administration of justice. And so that just made me reflect on what decisions like Pena-Rodriguez versus Colorado do. And I think one thing that it risks doing is creating this pacification effect. Every once in a while we see the court hand down a quote unquote good opinion, even though if you kind of scratch below the surface it's not even all that good. And it gives them cover to do things that are horribly bad, right? They give us these crumbs of racial justice while they perpetuate extreme racial injustice, while they make it harder in some ways to even eradicate racism from our various systems of law. And so, given that, it just strikes me, it struck me very profoundly, this idea that we get this opinion where a lot of scholars said this is a good thing, and for Mr. Pena-Rodriguez, it undoubtedly was a good thing that the court ruled the way that it did. I don't want to take that away from him. But is it good for all of the criminal defendants who follow, who won't have the overt racial bias in their case, who won't be able to show that the bias significantly motivated a juror's vote, who may not be able to talk to the jurors at all? Because the Supreme Court said at the same time that even though we're creating this exception, we're not disrupting the rules that prevent you from talking to jurors in the first place. And so somehow you're supposed to get this evidence of racial bias without being able to talk to the people who are in the room. And so the court just creates all of these structures and standards that insulate the most common forms of racism from review. And so what the court is actually doing, I would argue, is further ensconcing racism into the system and making it even harder for us to catch, harder for us to detect, and then harder for us to disrupt. Which again made me think, are juries, are secret juries good for Black people and other people of color? In a world where we know people of color are disproportionately removed from jurors by prosecutors, where they're disproportionately disqualified from jury service altogether, so we're not even sure, you're not even guaranteed that there is a person of color in the room to even detect or catch the bias that may be uttered. And even if they do, it's not quite clear what they can do about it. Why would we ever think that this institution would be fair for us? And if we know that there are examples of racial bias, express overt racial bias being uttered during jury deliberations, why wouldn't we think that there isn't kind of more covert bias being uttered? Why wouldn't we think that implicit bias doesn't affect jury deliberations when we know people have implicit biases? And so then why do we have this system? Why would we adopt a system indiscriminately from a time and a place that looks nothing like a professed multiracial democracy that hasn't quite gotten there yet, that has never taken the time to deal with its deeply racist roots, who is trying to blind itself to the way the racism manifests in society today? Why would we think this institution is good for us at all? But when you ask that question, you always get the retort, well, what would you put in its place? And I don't think that's my job to figure out. I do think it's our job to think about when we adopt systems uncritically from countries that look nothing like ours, from a time where we weren't considered part of the body politic, whether those systems serve us. And that's what this chapter does and asks. It asks, well, what are we doing when we prop up a jury system as a system of fairness? We herald juries as these democratic bodies that get us close to justice, whatever that means, as carefully curated by evidence rules, in which people of color, women, others weren't even in the room to help do the curation process. And so that's what my chapter's about. It gets a lot of pushback from folks who say you don't have any other options. You are trying to disrupt or dismantle the jury system altogether. What does that say for justice? And I believe in juries to a degree. I'm from DC. You can get a really good jury in DC. You can win trials that you probably can't win in a lot of places in DC. But that doesn't mean we shouldn't reflect on these bodies that are supposed to be core to our democracy, given the fact that we know that racism and racial bias infiltrate them in so many different ways. And if racism and racial bias infiltrates them, we're not even beginning to discuss all of the other biases that may affect the system in all kinds of ways. And so, yeah, so the chapter is really just a call to question our systems and our laws. And it's a call to re-examine our institutions and whether they're serving us in the way that we're being told they're serving us. And if they're not serving us in the way we're being told they're serving us, to at least be honest and reflect on that as we talk about juries, as we talk about the system, and as we teach our students about how these systems operate. And I'll stop there.
Thank you. I've really appreciated your work in this area. Those of us that teach from George Fisher's textbook, it starts with 606B and jury secrecy, and I always have to remind my students, so what is the remedy? And a lot want to, shoot their hand up and say, oh, conviction overturned, and then there's always one person who read very closely and is like, you just get a hearing. Yeah, and it's obviously not very satisfying given what one has to show even to get a hearing. Okay, so I am going to present my chapter on presumed expertise, police officer testimony. I write normally in criminal procedure 6th Amendment, right to counsel. So this was a new area for me scholarship-wise, and I feel very well supported by everyone on this panel in entering sort of this new area of thinking and of scholarship. And so I want to talk about determining, I do always show clips of my Bennett in class, but I want to talk about some of the rules that we rely on to navigate this concept of expertise, and then once you're deemed an expert, what kind of sort of opinion, testimony that you can give. I'd like to talk also about how society, judges and jurors, presume that police officers, when they get on the witness stand, whether they are deemed an expert or not, have this air of credibility to them, and then some of the dangers that can result. And then lastly, to discuss how defendants, particularly marginalized defendants, can mitigate some of that presumed credibility. And again, all of these chapters, the book will be out in 2026. I don't know if I made that clear. Okay, so this concept of determining expertise, the reason why I do show this clip, and those of you that are familiar with my cousin Benny, is Marissa Tomei's character doesn't necessarily have a PhD in auto mechanics, but she has this deep, lived experience in working in her family's auto body shop. And she basically schools everyone in the courtroom with her expert knowledge there. But most of my students, and most people, I think, don't assume that someone like Marissa Tomei, without sort of all of these credentials, can be an expert. And the rules that we work with to draw these lines and make these determinations, I have them all up here. These are the federal rules by number, and many states have adopted the same numbers, and if it's not the exact same number, then it's the same concept. So 701 is what allows basically opinion testimony from lay witnesses, and they just have to avoid giving opinions about things that would otherwise rely on specialized knowledge, scientific or technical knowledge. 702 then is on the other side of that, so people who can give opinions that do rely on specialized knowledge, technical knowledge, specialized credentials perhaps, and then they can opine and are given much more latitude by judges. 703 regulates what an expert can rely on, what is their basis of knowledge, and then 704 dictates how much about the ultimate issue someone can testify about, and generally in criminal cases, experts cannot testify that, say, a defendant definitely has the requisite mental state. So these are the rules that we're working with as we navigate this area. And I open the chapter with two anecdotes. And so it's sort of two criminal cases, defendants in each, and in this one in particular, charged with robbery and murder. There's some correspondence that's picked up from social media, and a police officer gets up and testifies and couches their testimony in the fact that they have all of this experience investigating cases and in deciphering coded language, so that when the defendant in these social media exchanges uses the terms lick and sweet lick, he means robbery, and that this was sort of low-hanging fruit, someone that they could rob. And this person is not. The officer is not deemed an expert and is allowed to rely on all of his expertise and experience investigating cases. And this defendant is convicted. So in the next case, it's a drug-related crimes involving cocaine possession. There's alleged co-conspirators, and again, conversations between the defendant and again their alleged co-conspirators. And the law enforcement officer, relying on all their experience as a police officer and having listened to and decoded coded language between accused persons, is able to translate for the court what these coded words mean. This person was deemed an expert, and again, the defendant is convicted. And so you see lots of cases where police officers are testifying. Sometimes they're qualified as experts, sometimes they're lay witnesses, and when they are lay witnesses, they're allowed to opine in ways that a traditional lay witness would never be able to opine. Or if they're deemed an expert, the basis of their knowledge is just the fact they've been a police officer for a long time. And so I'm arguing at the courts whether they're recognizing an officer as a lay witness who can opine broadly, or an expert witness who can base their knowledge off of things that aren't actually expertise. They're misapplying. The judges are misapplying the rules. And so what we get when we have officers testifying is that they're carrying this presumption of expertise, and there's lots of social science research here. Vita Johnson has done some great work. Anna Levosky, who's a historian at Harvard, has done really great work on this idea that police officers are deemed and presumed with an additional layer of credibility just based on their status, often wearing uniforms when they come to court, and then opining again about all sorts of things. And I've talked a little bit about the fact that judges are misapplying these rules, 701, 702, and 03. And at the same time that the jurors and judges are assigning additional credibility to law enforcement officers, they're also assigning less credibility to accused persons. Brian Stevenson's work is great here. Daniel has written in this area. But this idea that, and also Bennett Capers, black people in particular, black defendants, brown defendants, just the fact that they're in the courtroom sitting next to defense counsel, there's this concept that like, oh, they're already guilty. Why would we even have this whole trial unless this person was guilty? And so we have this diminished credibility of the accused person and this elevated credibility of police officers. And so part of the chapter is just recognizing this danger and this disparity that jurors are obviously subject to, but judges as well. And it kicks in when judges are making these determinations about how much these police officers can opine. And so when did this start? This is not steeped in common law. Anna Levosky talks about the fact that Terry versus Ohio was really a turning point. And so in the late 60s, early 70s, this is also when we have sort of the increase in mass incarceration is parallel at this time. But we had the US Supreme Court rely on an officer's experience as a police officer to actually make constitutional determinations about police officers' actions, about defendants' actions. And you used to have courts look at testifying officers with a good dose of skepticism. And then sort of after this point, we're starting to routinely see police officers in criminal cases showing up and testifying about their experience as investigators in this case. It's sort of a double whammy when you have a police officer who has been a participating investigating officer to then testify in a case. Sometimes you have officers who haven't been testifying, but they're given that much more credibility when they participated in the investigation. Judges are also treating them as if they're disinterested witnesses. as if they're somewhat neutral, when they are in fact not. They have a deep interest in this case. They're working hand in hand with the prosecution. And Vita Johnson, one of her interventions is that we should be shifting the way that we instruct jurors, and I'll get more to that in a moment. But this was really a shift that started, and Terry versus Ohio, I'm arguing is somewhat of a catalyst in this shift and the way officers are treated on the witness stand. So some of the dangers, and some of this has come out already, is that it tips the scale, obviously in favor of the state, in favor of the prosecution. It's impacting the way that judges receive officers as potential witnesses. Even if the state does go through the process of deeming them or qualifying them as an expert, there's this idea that, yes, of course, based on all of their experience just investigating cases, they're an expert in gang affiliation, they're an expert in coded language, they're an expert in all sorts of things just because they're a police officer. And then when there isn't any effort from the state to introduce them as an expert and they're allowed to testify as lay witnesses, they're often given all of this leeway to opine about matters that should be reserved for experts. And this means that the state has avoided having to do certain pretrial disclosure, which you would have to do with an expert, and so it does allow a little bit of sort of shoehorning or skipping steps when you have an officer that's testifying as a mere lay witness. And then again, jurors then receive this testimony that's not very well filtered by the judge with this trumped up notion of credibility, and again, combined with that simultaneous diminished credibility from the accused person. And so what are some of the potential interventions? And I argue that, yes, police are quite interested in the outcomes. They do lie. There's lots of social science research on the phenomenon of test-lying. And that defendants should be able to request the type of instructions that are given when a confidential informant testifies or when a cooperating witness testifies, that jurors, you should receive this testimony with caution. It's a really simple jury instruction, and there is it exists, in another context. And so there should be this ability for criminal defendants to ask for and to receive this jury instruction that, yes, please receive this officer testimony with caution. And then what's been happening and developing really beautifully, particularly in the state of California and the Bay Area, is this idea of community experts. So some of you may be familiar with, in Silicon Valley, Debug. It's a fantastic organization run by Raj Jayadev, and it's spread sort of throughout the country in terms of this concept of participatory defense. But in Silicon Valley, they've been sort of training experts. They're just community members, some of whom have been formally incarcerated and had affiliations with gangs, to then testify in pretrial proceedings, sometimes in sentencing hearings, when there's a sentencing enhancement for gang affiliation. And this is something that's quite unique to California state cases. So pre-trial, they might testify that, we shouldn't have the sentencing enhancement. This person wasn't affiliated with a gang based on my own knowledge of this organization, or based on my knowledge of this organization's recruitment policies. This person wasn't actually a member, or to couch their membership or affiliation with greater context. And given the pressures of this community, given the physical real risks and dangers, this person had to affiliate with an organization. And that can be quite effective in sentencing. And it's really an opportunity to counter a police officer who's often deemed an expert about gang affiliation, that in all their experience basically arresting people and claiming that they're in gangs, they're then able to opine about membership. And so Debug has been really successful about either removing the gang sentencing enhancement from cases or decreasing a real significant time when it comes up at sentencing. And then also in California, not too far away at Loyola Law, there is an independent forensic gang expert college where they're training individuals who have been incarcerated, who have been had gang affiliation, to be experts in cases, whether testifying or even consulting experts with the defense team. And they've been incredibly successful, particularly in case consultation with defense teams. This is how to talk about, this is how to couch, this is how to navigate issues when it comes up with accusations that your client has gang affiliation, or if your client does have gang affiliation, this is some of the context you can bring to the case, particularly at sentencing, as we're trying to give a whole picture of who a person is. So that is my chapter. It was a teaching or sort of a learning exercise for me. I mentioned this was a new area for me to write in, but I'm hoping it can be an effective tool for students and obviously practitioners as well as they're sort of navigating and confronting these issues in their cases. So thank you.